You guys want to? We got 1 minute left, but you guys want to start doing like a panel about law stuff? Like, all right, cool. Hold on, I want to hear it. Like, I don't want to be that guy that's like, "Can I hear you again?" But like, the lawyer panel. Let's turn up for it a little bit. How about that? Who here wants to hear about law stuff? Oh my God, I feel alive, y'all. Thank you so much. Yeah, we'll do introductions. We're gonna go ahead and kick it off because it still says 1:59 on my phone, but maybe I took a screenshot. Who knows? I have time blindness. So welcome to Protecting Your Brand and Bag, Intellectual Property 101. We have a panel of lawyers, and there is also lawyer friends in the audience. I was like, you were hiding behind somebody now. That's Chrissy. Chrissy's great. And we have lawyer friends in the audience too, so we might phone a friend if you ask us a question we don't know the answer to. It's happened before, I think, yeah. So, yeah, so we're gonna get up here, we're gonna talk to you guys about your brand, your bag, protecting your stuff. First thing we wanna do before we do introductions is how many of you consider yourself to be a creative of some sort? Fantastic, love that. Never stop. How many of you are a business owner of some sort? Even better, we have cards available afterwards. And then how many of you are intellectual property, like aficionados? Like how many people know IP? Good, I was about to say, I know Chrissy does. Excellent, and Dave does too. So yeah, fantastic. And how many of you just wanted to see what lawyers talk about for free? Well, that's yeah. I mean,
it's a very odd interest. I think.
It's a very odd interest. So, well, without further ado, we're going to introduce ourselves so you can decide if you want to stay or not. And let's go off and start with Professor Christopher Katropia.
I appreciate that, Noah.
Yeah.
Oh wow, I don't even get these in my classes. I am a law professor at GW here in DC, and mainly focus on patent law, but also other areas of intellectual property law. And I've got a law firm that mainly does patent stuff, Bay & Katropia PLLC. And I had the pleasure of, now we're going to date both of us, quite some time ago teaching Noah here at the University of Richmond. So.
Yeah. 2015, class 2015.
Oh my gosh,
man.
Don't put the dates on there.
Yeah, that's, you know what year it is now?
I don't want to know.
Don't think about it. All right, and Leo.
I'm from Puerto Rico. I have a background in computer engineering and then went to law school and started working at a firm there focusing on intellectual property. Then I answered a job posting from Noah on Twitter, and they flew me here to MAGFest and hired me here a few years ago. So
yeah.
I've been participating in panels with him since.
Yeah, this is what, your third year anniversary of the firm? Because we're at MAGFest? Yeah, that's how we track it, because our firm loves MAGFest. And my name's Noah Downs. I'm a lawyer, but I'm a cool lawyer, like everybody up here. And I go on the internet as MyLawyerFriend. I am a named partner at Premack Rogers Downs PC, based out of Washington State, not DC. But I live just down the road in Richmond, Virginia. Don't come try and find me. Yeah, Richmond gang, rise up. But yeah, so we're here to kind of talk from all our disparate experiences with intellectual property and kind of going through things. We have notes on things. However, we will be leaving some stuff at the end for questions and answers. So if you have a question, write it down, because you will forget it after 30 to 45 minutes of lawyers talking about law shit. By the way, I do use the shit word occasionally, and we're allowed one F-bomb per panel.
Okay, I'll use it wisely.
Is it per person?
Per person per panel.
It's tradable. We have to figure out, right?
Yeah, and Leo doesn't drop the F-bomb, so I get his. Yeah, sorry about that. So if you hear that, just know it's par for the course. Real quick, before we start, God, so many disclaimers. I'm so sorry. We are lawyers. Everything that we talk about today is for informational purposes only. It does not create an attorney-client privilege relationship. It does not create an attorney-client relationship. If you are interested in securing legal services, we are available for hire, but your being here or asking questions does not create a relationship between us, except unless you're already like our client. I see a couple of you. So thank you for coming. That said, when you ask questions at the end, we're going to ask you to be as non-specific as possible, because we cannot give you information based on specific details. We can only talk about informational things in general. So leave out the context. I know you think it's important, but frankly, it might not be. So that's that. And what I'm trying to say is, don't take this legal information and try it at home. Go to a friend's house. All right, cool. Without further ado, Guys, let's talk about what is intellectual property. How many of you out there know what a copyright is? Oh, wow, that is way more than is normal. Okay, I'm a little intimidated. Cool. How many of you know what a trademark is? How many of you think you know what a trademark is, but you're really thinking about a copyright? There you go. How many of you know what a trade secret is? And a patent. Good job. At least we know that hands can be raised here. So the way that we're going to kind of break this down is we're going to talk about what those are, each and individually, and then we're going to go into how you can protect them, through LLCs, contractor agreements, et cetera, and build that out. I am going to stay away from patents because it's kind of like the Lion King when Simba was like, "What's that dark area over there?" I'm like, "It's patents. I don't go there." That's why we have Professor Katropia up here, Chris.
That's fine.
Because he knows patents. It's
not a dark area either. You don't need to worry.
Yeah,
it's not that dangerous.
Patents are terrifying. So let's dive in. I'm going to start off with copyrights because Leo's been doing more trademarks than me lately. So what is a copyright? A copyright is something that is fixed in a tangible medium of expression. But what does that mean to somebody that's not a lawyer? Basically, if you have an original expression, original work of art, original creation, and you make it and you put it in something in a form that is not transient, it is not ephemeral, then it is something that a copyright could attach to. You could potentially secure a copyright in that, and that's super important. For example, if you draw a smiley face on a sticky note, you've theoretically created a copyrightable work. You don't have a copyright just by virtue of doing that. You have to file with the Copyright Office to get a registration so you can enforce your copyrights. But your works that you make are copyrightable. You have a copyrightable interest in them. And that's really important to start here because everything that you do in the content world, in the creative world, you're creating copyrightable works all day long. You can protect certain aspects of code, artistic expression, music, which is artistic expression obviously, but I'm thinking about fine art, you know what I mean. You can protect all sorts of things. Back in the day, they actually started adding sea monsters to maps so that you could protect your map designs from people that are ripping off your map designs. So copyright, everyone in here who is a creative is creating copyrights day in and day out, which is why we start there, to make sure that we have that basic term kind of understood. That is what a copyright is. Am I missing anything on copyrights, guys? I want to lay the groundwork before we dive into the hardcore stuff.
So you said expression, Noah, right? So it protects the expression, but it doesn't protect the underlying idea.
Right.
Right. So if I was drafting up some computer code, I might get protection for the specific code that I draft, which is kind of a fun language maybe to read. But I certainly, by copyright law, would not get protection for the underlying idea. If you've got some really cool algorithm, or maybe even it's the rules for the game that are underlined or embodied in it, right? That would not be copyrightable.
Yeah, on that note, facts are not copyrightable. So that's why you can't copyright the phone book unless you make up names and put them in there, which actually is something that phone book companies used to do to protect their copyright and prevent people from copying them. And they still do, actually, to my knowledge. And so that is what a copyright does. You can't protect facts and you can't protect ideas, but almost anything else is fair game. Now, copyrights don't include your brand. They can include your branding, like the actual artistic expression of your logo or the stylistic aspect of your name or font or whatever. But your brand is protected by a trademark. And this is where I'm putting it on a T and handing you a baseball bat. Talk about trademarks, Leo.
Just real quick regarding copyrights, we use the word copyrightable a lot. It doesn't mean that you need to register your work in order for it to be protected by copyright. Once it's fixed in the medium, like Noah said, the copyright is born.
Yeah.
That was
if
it.
you want to sue somebody, you have to register the copyright. But you can still protect through the DMCA, which we'll get into later.
So trademarks are identifiers of the source of a product or service. So, for example, if you have, when you see the word Coke, you know that it's going to be delicious because you know where it comes from and who makes that Coke. The same with, you hear Super Mario, you know the game comes from a Nintendo and you know the quality and the kind of game that you're going to be playing. If I make a game and I call it Super Mario, people are going to think that it comes from a Nintendo. And I don't know how to make games, so my game is going to suck. And I'm kind of piggybacking on the value that they give to the trademark that they have. Mm-hmm. So trademarks are classified depending on their distinctiveness, and there's four types of trademarks. There are arbitrary trademarks, which are terms that don't have anything to do with the product that they're being used in connection with. For example, Pepsi. I really like soda. Pepsi is a word that doesn't really exist, and they use it for a soda product. That's an arbitrary mark because it has no relationship. There's also
Fanciful.
fanciful marks, which are words that have suggestive.
Yeah.
Suggestive marks kind of give you an idea of the product, but not directly. Like, for example, copper tone for a sunblock, or Greyhound for the buses. Those are suggestive marks. There's also descriptive marks, which, as the name says, they provide a description kind of for the product that they're being used in connection with. For example, if you have an ice cream that's called soft and creamy, it's not explicitly telling you that it's ice cream, but soft and creamy are characteristics of ice cream. What are you doing, Noah?
Sorry, different example next time.
Well, we're adults. We're adults, Noah.
Yeah. Sorry, we're at MAGFest, man.
Yeah.
So.
And
I don't know what kind of ice cream you're eating, Noah.
Don't worry about it, man.
Yeah.
Okay, well.
Don't worry about it. Popsicles.
Yeah, those are hard and.
God, stop.
Yeah. Yes. So the descriptive marks don't get automatic protection. They need to be used in commerce with in connection with a good for at least 5 years in order to get what is known as what's the
Acquired
term?
distinctiveness. Acquired distinctiveness or famous marks.
Yeah, but there was a different term. Yeah, distinctiveness. That you need to use it for at least 5 years in commerce to kind of show that the public makes a connection between that mark and the product that you're using it with.
Yeah.
And the other term that is not really a trademark, but is part of the analysis, is generic terms, which are not trademarks and are not protectable by trademark law. And that's, for example, if I sell apples and my brand is Apple. Those are not protectable through trademark law because you would get a monopoly on the word that means the product.
Yeah.
So that's pretty much a primer on trademarks.
Yeah, and that's the thing, is since it's a source identifier, it's got everything that's built in with it. It's got the goodwill that comes with the brand, it comes the quality of the brand, everything that's built into building out your brand as the source of the goods or the source of the content that you're putting out there is incredibly important. So typically what we find is the strongest trademarks are going to be your fanciful and arbitrary trademarks. So for example, Google with a search engine, kind of pretty good there. Or I don't even know if Spotify is anything with music.
I wouldn't think it'd be suggestive. I
Yeah.
think it probably would be. Is that even a word that we've known before? Or maybe
I don't know.
Maybe that's fanciful.
It might be fanciful, yeah.
Yeah.
And so the more distinct your word is from the goods and services you're offering with it, the more likely it is that you're going to be able to protect your brand through that trademark.
Right. Or Apple is arbitrary for computers.
Right.
Right. So you did incredibly strong.
Or for doors.
Yeah, you could have Apple doors, I guess. You could have Apple anything.
Yeah.
And also, like I said, for the term copyrightable, trademarks are protected since they start being used in connection with the goods. So you don't have to necessarily register your trademark in order for it to be protected.
Yeah.
As soon as you release your game and you have the name of the game, you're selling the game under that name, you have trademark protection for that name in connection with games.
And that's because we're a first-to-use system as opposed to a first-to-file. So one of the number one questions that we get is when you're trying to protect your brand, people say, hey, I've noticed that somebody else is using this name that I want to use. If we file it first, am I better off? And the answer is no. They're using it in commerce, in theory, with the same goods and services you want. So we need to examine another option. One of the best places that we can make some sort of pivot like that for trademarks is at the beginning, when you're starting to build out your business and when you're starting to build out your brand. Before, let's say, how many of you are game developers, for example? Fantastic. I love that for all of you. If you're building out your game and you have a working title, so to speak, right now, and that working title is not something you've not done marketing on it yet, then right now is when you want to be kind of checking to see if you can get the trademark for it, if it's available. Because right now you can pivot. If you've announced your game, it is much harder to change your name down the line and rebrand and invest a lot of money in that, which is why we put in so much work on the front end, because the trademark office is currently 16 months behind.
The federal government's been hiring a lot of people.
Yeah.
It's working incredibly efficiently, and so
Yeah,
that's why.
Yeah. There's a puppy at the front of it, some sort of Doge. Anyways, but yeah, so it's been absolutely brutal. So important to remember, those are the two most common types of intellectual property buckets that you'll run into: is copyright and trademark.
And just on the on your point, Noah, on the trademark side, is Noah's totally right. You want to look for a identifier that no one else is using, and that should synergize with what you want to do as a business, right?
Yeah.
You don't want to have somebody else already have a product out there that has the same name or identifier as yours, because yours is a whole hell of a lot cooler and neater, and you don't want to be confused with theirs. And so I think that a lot of times the advice that they're giving you links up with just what you should be doing if you're thinking about kind of starting a business or creating a product, right? You want yours to be unique.
And now,
as a creative.
Yeah, you want to be creative. You want it to be a reflection of what you are putting out there. Actually, let me do a little bit of audience participation real quick, because we've gone through definitions, and definitions are boring as shit. So real quick, if you are creating a fast food brand and you wanted to call your fast food brand McDonald's, M-A-C, Donald's, spelled completely differently, different stylization, everything. Would you be able to do that? By show of hands, who thinks you can? Okay, who thinks you can't? All right, who doesn't want to raise their hand? All right, great, fantastic. So McDonald's and McDonald's are similar in sound and overall commercial impression, which means that McDonald's trademark actually prevents you from getting McDonald's with fast food, as long as McDonald's is using their mark in commerce still, which they are going to, because they have billions and billions served. Save the question. I believe in you. Yeah, write it down. Now, if you were looking at a brand that you want to do, and you see that, like, you want to call your movie Existence, but you're aware of the 1995 horror thriller called Existenz, that spelling difference also doesn't help you out. It needs to be different in overall sight, sound, and commercial impression. So you can't do small variations on it to make the slight difference and change it around so that you can kind of workshop your trademark to get towards where you want. You're going to have to start from ground zero on that front. In addition, real quick, just before we move on, trademarks also, just because you get the trademark for Apple, for example, doesn't mean that you own the word Apple in the world. It's split up by 45 different goods and services classes. So essentially you can have Apple for music or computers, or Apple for doors, completely separate, and they can coexist. So just because someone else has your name doesn't mean that you can't use it as long as you're doing something different with it. Also, if you say, hey, I'm the Richmond Apple, geographic identifiers do not matter. So you have to disclaim those. I think that's good for trademarks, right? Yeah. Feeling good up here so far?
Yep, and we're going to go back and talk about, I think registration is a very interesting question as to whether you should pay someone to register your mark or not. Because
we would say you should.
You should. No, but we'll get back to, I think that's one of the, to me, I think the way they've set it up is identifying, hey, what intangible fits in what bucket? And then the second question is, well, should I even care about this? Should I pay an attorney to do this? And I think we'll get back to that. But I think that's particularly trademark, it's a big question is, probably should register. But
so that's copyrights and trademarks. That's the intellectual property that most of you are going to run into in your lives, and most common at least. Your copyright will show, if you're a content creator, for example, your copyright is what you create. Your trademark is what the label you put on it. That's your brand. Now let's talk a little bit about patents.
We can talk a little bit about patents. So I think one of the interesting just differences between trademark and copyright is with patents, you're only going to get patent protection if a patent office issues you a patent. I think that's one of the kind of initial kind of just groundworks about this. And patents in general, there are two flavors. There's a utility patent and a design patent in the United States. And utility patents protect functional things. So kind of getting back to the example Noah was talking about with computer code, the expression of the code is protected by copyright. You might be able to get a patent on the underlying functionality or utility of it, right? It would be the same if you had like a joystick controller. I might be able to get a copyright on the way the kind of cool design looks, etc. But you would look to get a patent on the actual functionality under it. It's very difficult and expensive to get a patent. You're looking for something that's new, no one's done it before, and not only that it's new, it's got to be non-obvious. So it's got to be like an advancement beyond what people have done before. And if you think you've got something that's new and non-obvious, you would file for a patent. We'll talk about this maybe. You'd probably file for a provisional patent, which is a cheaper, earlier filing where you can kind of put your flag in the ground and you get about a year to decide it. But you file for a patent application where you would describe, you got to tell the patent office and eventually the world how to make the thing, how somebody could create it and use it, and then you file for a patent, the patent office examines it. If they think that you're claiming, you have these long sentences at the end that describe the utility that you're trying to get exclusivity over, you might get a patent 2 to 3 years, and maybe $10,000 later in fees and attorney fees, which gives you a sense of that. Those are utility patents. There are also design patents, which are on ornamental aspects of things, which have gotten to be a lot more prevalent now that we're in the kind of design economy that maybe Apple has been on the forefront of, or now
that we live in
behind
a capitalist hellscape.
Exactly right. And so that can help if it's the actual aesthetics of the item. There's some benefits of getting design patents. They're cheaper to get. They get out much quicker. I think like you all have a client that does dice towers, right? Like that would be an area where maybe a design patent actually makes a lot of sense. Long time ago, I used to help a client out called Motorola that had these little bar phones that had these nice face plates. You could put a new face plate on it. I don't know if anybody remembers these old ones. They would use design patents to go after these faceplate manufacturers because it was a really easy way to stop the importing of those things. That's a very, very super quick part about patents. The other benefit about patents is if you get a patent, you can go after individuals that haven't even copied. They might have done their own independent development. They might have come in second. And so while it's a lot of cost on the front end, there's a really big benefit on the back end. So it's something I think you would think about if you're designing some hardware or something physical. It's a little tougher in the intangible space.
Software space.
Exactly right. I think there's a little bit of uncertainty right now as to what aspects of, is this a bad word around here, AI development, et cetera. But in general, I would look to do a patent if I've got something that's really cool and physical.
And you'll notice when we're talking about patents, we're talking from the perspective of you put everything down. You show what your invention is, because historically it's around inventions and stuff like that. You show what your invention is to the specificity where someone else can recreate it. But unlike trademarks and copyrights, patents expire after 20 years. Trademarks you can upkeep and keep them up as long as you use them in the business. Trademark, lasts as long as Disney decides. That's a whole thing. We'll talk about that later. But patents last for 20 years.
That's right, 20 years from filing. Design patents are 17 years from issuance, but yes, they're shorter lived.
And the reason is because they want to put the ideas out there. They want to give you, hey, you're first to market, good job. But then they want other people to iterate and build on what you've made. So the idea is that a policy reason is to let you exploit your patent, make your bag, retire, get the heck out of the market so somebody else can then invent on top of what you've invented. And it's cutthroat and ruthless. So I think it's fun.
It's fun. It's a costly endeavor, so I think it's something you would make a real serious decision as to how it fits with. I mean, this is going to be my mind. Fits with your, even if it's not business model, it's like what your creative trajectory is. Yeah. What space do you want to keep for yourself, or make sure is shared with others? Right? I think we might talk about this. I think intellectual property law can be used in both ways, either to keep people out or to make sure that people are included, right? You can use IP as a force lever to make sure that everyone that you want to play in the game plays in the game.
Go ahead, Lee.
Yeah, so and something else that is interesting regarding patents is that when you try to register a copyright or a trademark, the person doing the analysis of whether you get the copyright or trademark registered or not is a lawyer. So it's purely a legal analysis. For patents, it's a person that has ordinary skill in the art. So it's an expert in that field. So if you're trying to patent, say, some machine, then it's an engineer who's going to be evaluating your submission. So you have to convince him, and he not necessarily you can just be like citing case law or statutes. You need to actually understand what the device does, how it's made, how you can accomplish it, make it a reality, and that's it. Yeah, I just want to mention that.
Yeah, and that's really big nowadays when people say AI it.
Yeah.
You've never heard that before, right? We're just going to AI it.
It's brutal.
The office has been really pushed back about, no, like, what do you mean by AI it?
Yeah. And then finally, the last of the pillars is trade secrets. And it's kind of the other end of the spectrum, whereas copyrights, trademarks, and patents can have some form of registrability where you register your to get enforcement. Trade secret, the minute the cat's out of the bag, you can't put it back in. So the way that you protect trade secret is not by talking to people. You just don't talk to people. Just stay inside or protect them via non-disclosure agreements. The problem is with trade secrets, the more people that find out that aren't under a duty to keep that information confidential, the worse it gets. And once the information is out there, you literally cannot prevent it from being used and being used in such a way as to harm your business. So when you're dealing with trade secrets, you want to make sure that you are keeping it secret, keeping it limited, and securing it with non-disclosure agreements, because those non-disclosure agreements will not prevent your secret from going back. You can't put the toothpaste back into the tube, but it'll allow you to go after the person that violated the non-disclosure agreement. And that's really your only recourse. And so you don't really have a registration aspect there. We also have the Trade Secret Act, which allows you to get certain protections and statutory benefits to kind of go after people that violate your trade secrets. But you have to sue people for that, and that costs a lot of money. So I figure let's talk about the thing that I hate to talk about, and that is, who here has heard the phrase fair use? All right. Who here likes fair use? I'll let you in. I hate fair use. Fair use is bullshit. And let me tell you why. And I'm going to let Leo and Chris talk about the factors of fair use for a second before we move on. But fair use is a defense. If you were trying to claim, hey, I can do this, it's fair use, then you are assuming you're going to get sued and get in front of a judge and have the ability to defend it. And by the time you do that, you've spent tens of thousands of dollars, if not probably because you're using a copyright law, you're going to be in federal court, so you're going to be up to like hundreds of thousands of dollars. So who here can afford hundreds of thousands of dollars to claim fair use by a show of hands?
Oh,
all right, cool.
He's buying the first round tonight.
No, I want that man as a client.
The first one?
And if you just didn't feel comfortable raising your hand because we do live in a capitalist hellscape, find me afterwards. I need you as a client. But yeah, so fair use, in my opinion, is bullshit. But that said, we do need to briefly talk about the 4 factors of fair use. And because it makes me see red, I prefer not to do it. So y'all talk about it.
Okay, so like he said, fair use is a defense. So you pretty much are saying, like, I know I infringed on that copyright, but it's justified because X or Y, and that's a decision that the judge is going to make when the case has been resolved in court. There's no really like a clear-cut way of determining if something is fair use or not. And the courts usually use, like Noah said, use 4 factors to determine whether fair use took place or not. The first of those factors is the purpose and character of the use. This is pretty much taking into account whether the use of the work was commercial or was not. Did you profit from that use? Was it educational? Was it something you do in benefit of someone else? Mm-hmm. They're going to evaluate each case and determine if the purpose and character of the use actually supports a fair use defense. The other factor is the nature of the work. It's fictional versus factual kind of work. If it's something that is fictional, it's usually completely made up by the author, and it's less justified for calling it that someone uses that, because you don't really need to use content that other people created completely. When your work is based on something factual, it kind of makes sense that people talk about it, and they might use something from your work when talking about it, because it's something that happened. So courts are also going to evaluate that, and depending on how the work was used, they might decide that it was fair use or not. Do you want to take the other?
Well, you can do that. I mean, you can do that too.
Okay. The other factor is the amount and substantiality of the use. So if I use a sample of a song that is 2 seconds, it's not the same as if I use the whole song for something. And well, judges are going to take that into account, because using the complete work is like I pretty much just copied your song. If I use a little bit only, it might have been like necessary for my work to make sense, or it might just be something that I added randomly and I'm trying to piggyback on the chorus of your song. And the final factor that judges take into account, it's the effect on the work's value. If I use your work and I make $1 trillion, the judge is going to take that into account, because I'm pretty much taking money that you should have made from your work.
Yeah, and I mean, I think the best way to think about it is that factor 1 and factor 4. How transformative is your work? So how much have you added to it, changed it, etc. And then factor 4, how much have you impacted the market for the work you're copying, right? Are you stealing direct sales, or are you stealing licensing market sales? But to the point that Noah made, Nintendo doesn't care.
Yeah.
Right? Okay, so Nintendo doesn't care. So they're going to sue and then make you figure out whether you're going to be able to afford a defense. And it's the same thing with the takedown. They're going to put the takedown onto YouTube, and you can. We might get to DMCA stuff.
We will.
You could push back and say, I've got a fair use defense. Well, then now the way the statute works, they could sue you in district court, and you're in the middle of it. So I think this is another one. If you're thinking about this, if it's a business, I would really worry about it. In some ways, your stuff's cooler.
Yeah.
You don't need Pokemon or Pokemans in your stuff. Create your own stuff.
Yeah, create
right?
Palma. Oh, wait.
I think it's a little different if I've got a video that I'm critiquing or commenting on.
Yeah, react channels on YouTube.
Yeah,
where
I think
truly
those
reacting,
are spaces where I wouldn't get. I think thinking about fair use.
Yeah.
But being ready to eventually have to make a decision.
Yeah.
Of I was fighting the good fight, but now I'm ready to. Those are the ones I don't want people to get too afraid of.
And
I don't want you to get too afraid.
We most often run into fair use when you're creating your fan-made projects. When you're creating your fan-made project, like you're making a fan game, or you're creating like a fan fiction or something like that. Fan fiction is not fair use, guys, by the way. It's great. Listen, I love AO3 as much as the next guy, but it's not legal. And so that's why, like, when, for example, there's a famous, oh God, am I about to do this? What? Yeah. Well, there's a different one. But there's a famous AO3 author. For those of you who don't know, Archive of Our Own is a fan fiction website. And there's a lot of, like, fan fiction on there that's not safe for work. And there's one work in particular called Manacled. That's the reaction I was looking for. And it became really popular. And so the author, because it's based on the Harry Potter IP, and also, fuck J.K. Rowling, there's one of my F-bombs. The author said, I'm going to publish this work as a hardcover, but I have to strip all of the Harry Potter IP out of it because, yes, it's fan work, but it's going to compete with the main work. It's got substantial aspects of the Harry Potter IP, etc. And so it's not fair use. So if you are claiming fair use, you're in trouble. So don't do it. Your fan game is not fair use. Just don't do it. If you think that your thing is fair use, it's not. I've only told one person in my 11-year career as a lawyer that their work probably actually was fair use.
So I'll be a little, so I think, don't claim fair use, but I think it's worth creating a calculus of how likely will they see what I'm doing and what will my reaction be. I think if I went and walked around the merch area, I probably would see a lot of drawings.
What? No.
That probably involve some copying.
Yeah, there's
right?
some big pill. Anyways.
I mean, so, and so if somebody like say, well, do you think I've got a fair use defense? My answer would probably be no, but I wouldn't necessarily then say to them, don't do what you're doing. It's just understand what you're doing, right? And understanding what your exposure is, what would happen. And what's wild is I come here every year and those drawings are still there. Yep. And so I'm like, well, there's just some non-enforcement that's going on. That person's making a little bit of money. So I don't want to discourage people wholly from this stuff, but I think you need to be cognizant.
And here's the thing. If you're building your entire business off of using someone else's IP and hoping that you're claiming fair use, you're going to run into problems. For example, I have a client who their business exploded because they made effectively realistic replacements for like popular jackets. So like Soldier 76 jackets and stuff like that. It was fantastic. But he got to the point where he was being invited to Comic-Con, like New York Comic-Con. And who else shows up to New York Comic-Con, especially for his it was his Wolverine jacket. Well, Marvel showed up. And ironically, the lead enforcement agent for Marvel in terms of IP, his name is Eli Bard, which is also the same name as the supervillain in the Marvel Universe, and he did not appreciate it when I pointed that out to him. No people have sense of humor. Anyway, so they sent a takedown, and he tried to fight it, and I had to fire him as a client because he wasn't listening to my advice of saying, they have you dead to rights, and they're not going to give you a license. You need to build on your own IP. And so from there, fair use sucks. So that's what you need to remember. Let's talk about protecting your IP. Creatives in the room. Once again, raise your hand if you're a creative that has your own business or wants to have your own business. Sounds great. Fantastic. There's several different ways that you can protect your IP. I'm going to speed run this so we can get to questions, but chime in, tap me on the shoulder. How many of you have an LLC? All right, cool. That's a great start. How many of you don't know what an LLC is? Even better. An LLC is a form of a company. When you're creating your business, one of the first things that I do recommend for people is to create some form of entity, which is a corporation, LLC, et cetera, that you can put all your intellectual property in. It's a bucket. And then from there, you can put lids on that bucket and spikes on the sides so that people can't get at your IP. Only you can get at your IP. You can lock it up. From there, your company will own your IP that you're creating, your copyrights, your trademarks, your patents, your trade secrets, et cetera. And when people sign agreements with you or when you hire people or work with vendors, you'll have contracts with those people. Most often, those will be contractor agreements. One thing that we didn't talk about with copyright is that copyright is owned by the author of the work. So if you are hiring a contractor to do something for you, you need to make sure you have a copyright assignment or a work for hire clause in that contractor agreement. Because otherwise, that person you hire to design your emotes for a streamer, for example, owns all of those emotes until you have a piece of paper that says otherwise. And they can force you to take them down or leverage that against you. So contractor agreements, the number one thing that I recommend most of my clients get to make sure they're protecting their brand, their bag, and what they're hiring other people to do.
And work for hire has to be in writing. So even if you have a recording of a contract, of a vocal contract or oral contract, it doesn't mean anything. It has to be in writing.
Email to suffice, as we put it. But you do need to have some sort of contract. Contracts also save friendships. I want everybody to repeat after me on this. If you take nothing else away from this panel of lawyers, contracts save friendships. Say it. Close enough. And so contracts save friendships. If you and your friend are working together, you come up with the best studio idea on the planet, you're going to beat out EA, you're going to destroy Blizzard, everything. Or whatever monopoly they all become eventually. I have some really strong opinions. Anyways, if you're going to do that, the two of you need to have a contract. Because otherwise, who owns the IP? Who is getting the money? What's the split? Who's in charge of what? What's the responsibilities? Where is this company based if you're across state lines or across countries, etc.? Contracts save friendships. That way, when your homie says, hey, I thought you were going to do this, you can point at a piece of paper and say, yo, you were going to do this. And that's why you own 50% of this company. So either do it or get off the pot. And that will allow you to have effectively a neutral arbitrator over any disputes you have with your business partners.
Yeah, you all have done, the relationship's always the best at the beginning,
Yeah.
right? It's only love,
honeymoon
everyone's
period.
happy, no one's complaining. You can decide where to go to dinner immediately. No one kind
Yeah.
of makes it, a year in, I don't want to go to Chipotle.
Where do you want to go to dinner? You ask me every night. I'm very happy. But yeah, so
Where do you want to go?
Where do you wanna go to dinner?
Let's go.
on the count of three, sorry. So contracts save friendships. Contractor agreements will also make sure that you actually own your company instead of a bunch of different people owning your company and you thinking that you own your company. And on top of that, when you create an entity, it's incredibly important that you have that entity have its own bank account, so you have separate finances from the company. Otherwise, the IRS or the federal government or somebody suing you can come after you and say, actually, it's you. You're using this company as a shell front. It's a piggy bank. I'm going to sue you. We're going to pierce the corporate veil, which is the term. It's terrifying. It's a horrifying term. I wouldn't recommend anybody be on the other side of that. And also, it shifts liability. If you have a company that you're properly using and you do create that fan game, despite going to that MAGFest in 2026, where that one lawyer who seemed like a curmudgeon said fan games and fair use are bullshit. If you do it and you get sued by Nintendo because you decide to make a Nuzlocke something for your Game Boy, then they have to sue the company. They don't sue you, assuming you set everything up. So whereas you might own a house, not in 2026, but like eventually, if you might own property or something like that, they can't go after your personal assets. They would go after the company's assets. The company might just own like a computer and some ideas. So it helps you a lot there and protects you from having to declare personal bankruptcy, which bankruptcy's bad, unless you need it, in which case it's great.
You want to take questions?
Yeah, I was about to say, I was going to hit the DMCA real quick.
Okay.
Because who's heard of the DMCA? Great. The Digital Millennium Copyright Act is something that is set up to create a process by which people who have a copyrightable interest in something can enforce that copyright on the internet. So the reason that we have it partially is because Google and adult websites. That's just not what you thought you'd see here today. But basically, there was a case where adult websites sued Google because of Google's image search feature. And basically said, hey, people can Google Mia Khalifa. Don't say if you know Mia Khalifa, but Mia Khalifa. And they get pictures of her on Google search. And that's our content. So they're getting it for free. Well, Google's a service provider. But what the websites really wanted to do is they wanted to go after people that uploaded images without their consent. So they created the DMCA as part of the reason to fix that. You have a takedown process. So if I'm a copyright owner and I see my content being uploaded by somebody else, I submit a takedown, an image, whatever it is. The service provider, the platform, has to take the content down. They don't make a judgment call whatsoever. If the platform does make a judgment call, they're doing it wrong. And then the other side has a reasonable amount of time to respond to that and say, actually, fair use. Don't do that. Or actually, I have a license to this, etc. And then it has to be reinstated by the platform unless party A sues party B within like 10 days. That's the DMCA in a nutshell. It's a nightmare. It was perfect for a while, but it's a nightmare now. It's also a tool that we use all the time, and also it's abused all the time. So if you hear the DMCA apocalypse is coming to Twitch, it's because people didn't license music on Twitch properly. There is a guy that's helping with that. He's in the audience right there wearing a green shirt. He's helping license music on Twitch properly. Raise your hand, Taffy. Yeah. He has a music label for that. Just quick shout out to my homie. So, am I missing anything on the DMCA before we take questions?
I mean, it can be your friend.
Yeah, the DMCA can be your friend, but just like...
I mean, if you're small, it's a nice way
Yeah.
to get something pulled down.
Yeah.
I guess I would say. And this is also why you might want to register your trademark. Amazon can be your friend with Amazon Brand Registry.
Yep.
So there are mechanisms on a lot of these walled gardens where you can use IP to push a corporation to act on your behalf, you can be on the other side of this.
Yep.
And that when you get kicked off the iOS store, and that's the Apple court that has
Yep.
said that, there's really not anyone you can go talk to but the Apple court, and the Apple court could care
Court
less.
of
Right?
Apple.
Yeah, court of Apple.
Yeah.
So it can be your friend.
Yeah. All right, y'all. So we are going to take questions. Actually, we have a microphone right here in the middle. So y'all, feel free to stand, or if you're not in a position where you feel comfortable standing or unable to stand, raise your hand. We'll make sure a mic gets to you. We will go ahead and repeat the question. Remember, we do not need context. Don't give us context. Ask your question. And if it's too specific, we'll tell you we can't answer it. So I'm going to go with this amazing person here who raised their hand. Did you want to? Can somebody get them a mic real quick?
Do you want to pass it around? Or?
Thank you for being cool. Can you
That'd be
take the
awesome.
mic
Let's
over?
just pass it around.
Yeah. Well, we'll do the line, but so people don't have to stand up.
Yeah.
Yes.
I have two questions. The first one was, what's the best way to go about an LLC? Like, I see a lot of sites online, but is it worth talking directly with a lawyer instead? Oh, is it the?
We can repeat it.
Yeah, we'll repeat the question. The question
good
is,
question.
what is the best way to get your LLC if you want to set up an LLC and you've determined LLC is good for you? We have the camera right there that's recording this. This is going on YouTube later, right? All right, cool. LegalZoom sucks.
That's why I wanted to hear.
Rocket
That's what I
Lawyer
wanted to hear.
sucks. All of these websites that offer services, legal services, listen, I have a vested interest in you hiring me to do legal work, but I'm not saying that for this reason. I'm saying this because I care. I get more work from LegalZoom messing things up, and I'd much rather you hire me on the front end to do it for X amount than to come to me on the back end when you've already paid and I have to spend double X amount to fix it. So go to a lawyer. Listen, we're not scary. We do free consults. Go to a lawyer, whether it's me, whether it's Leo, whether it's Chris, whether it's Chrissy, go to a lawyer. Only a few of them will charge you $10,000 retainers. So, all right. And what was your second question?
It was about. Is there a way to turn this on?
I'll repeat the question. Don't worry.
What's the best way to go about contracts, especially with?
Hire a lawyer.
Okay.
Yeah, if you ChatGPT your contract, then I'm going to destroy it. Yeah.
I think the mic is on. You just have to be really close.
It's on.
What
Yeah.
point do you need a contract in?
Oh, the minute you start working with somebody else, you need a contract. Because, like I said, contracts save friendships, they save relationships. It's super important. Okay. So, great questions. Those are fantastic foundational questions. Clap for that guy. All right. Now we have a wonderful line of people, and the mic seems to be working. So, go ahead.
Yep, mic is working. You just have to be really close. Collage in regard to fair use.
Collage.
So
Okay.
collage work in regard to fair use with art.
So there's a classic.
No, go ahead.
I can't remember the artist's name. He's also the one that did the recaptures of Instagram where he framed them up. He had sorry, I heard it. Richard Crenn. He's got an interesting book of Aborigines where he makes them look like punk singers, and they found that to be fair use. Now he is making a lot of money, so. If you came to me, I think you'd probably have a fair use defense. But if the collage is that you're cutting out, Donald Duck from a copyrighted Disney book and you're selling it, you're probably going to get sued.
Yeah, that's not a collage. That's just cutting out something. So.
Yeah.
Yeah.
So take it with what it is.
Oh, yeah, that's true. Hi. So, my question is, now that we're dealing with the age of AI, how do we navigate around all of, copywriting, all of that? Just as a general answer, because ChatGPT and all these Gen AI apps are just taking works, blatantly stealing them. And how do we just go and navigate that from work jump?
Great question. So AI, generative AI in general, and I'm going to tell you, I'm coming from a perspective, this is my bias. I'm coming from a perspective that generative AI is copyright infringement. In a heartbeat, it is. We represent artists, so we're an artist for law firm. And so generative AI is copyright infringement. There's no way around it. The problem is that one court disagrees with that right now. But there is a case that is fairly on point in most jurisdictions that's not that one court. that basically was the monkey with a photograph, monkey with a camera case. Essentially, the idea is that this photographer gave a monkey, or the photographer left this camera out, and a monkey took it and took a selfie. It was hilarious. And then the photographer tried to get a copyright in that graphic, and however, the court said you can't because you didn't take this photo, the monkey did. The monkey's not a human, and so no human interaction went into that. AI is not human, and so no human interaction is going into creating what it is in there. It's scraping a bunch of different human things and smashing them together, but at the same time, it's based on the fact that it's going to rip off other people's works. It doesn't happen without it. So in my personal opinion, AI is just copyright infringement from the get-go. And if you are able to prove that your work, like if it's a particular style of art or something, was used in an AI image through a bunch of factors, then I would absolutely take that case and go destroy some company with you.
And I think I would watch for the settlements. I mean, the Anthropic settlement is out there. I would look to see whether one of your books is in that settlement piece. There are the big law firm is Sussman Godfrey out of Houston. They are ready to go and sue these people, and they would be happy for you to join up in their class action. I think there's the other practical side of it, and that is if I don't want to get my picture grabbed up by one of these scrapers, I need to be really careful as to where I'm posting it. I mean, I know there's the law side of this, and then there's the practical side, right? And so if I put that stuff up on a Reddit thread, I just need to be ready for the fact that possibly somebody's going to loop that up in a training set, and now I'm, what is my enforcement? How do I find it? So I would just be practical on that as well. Also on the contract side, make sure if you're doing work for someone, you at least have contractual provisions. These cannot be used in training sets. We can't do this. I know it's just a contract claim, but at least you're doing that on the front end. I think that helps out a lot as well.
And on that note, make sure you're using services that in their end-user license agreements or terms of service aren't saying they're going to have a license to use your work to train AI models. I think we're going to have 2026 in particular, a bevy of services pop up that say, I am Instagram, but without all of the AI training and Facebook. And that's similar. Now, adoption is going to be interesting because obviously, we all hate Twitter. It's Twitter. But not as many people have migrated to Blue Sky as I'd like. So you're going to be finding your own community in these new spaces. But just keep in mind that you get to control who you interact with and how you interact with them. So, what's up, bud?
So I had a question when we were talking about trademark. We said basically with the idea of commerce. So let's just say there's someone out there who is not, if they are selling it, maybe they're selling it for nothing. And then I'm like, hey, I like their name. Or maybe by accident, I find out later they have a name. I'm making money off of the name. They're not.
Yeah.
Because they might have been in the space first. Do they have the trademark for that name? Or would I be able to claim, hey, I'm making money off it. They're not. I want this trademark.
Great question. Does somebody else want to tackle it? Because I talk a lot.
Yeah, as soon as you use it in connection with a service, it can be free as long as you're offering it and people can either obtain that product or the service. It has trademark protection. So even if the person is giving away their book or their game, they still have trademark protection over the term.
Yeah, and that's because in the digital age and the internet age, we have so much value that comes to us that's intangibles, like followers, clicks, acclaim, data, analytics. So it's really easy to say that even if it's offered for free, it is still a commercial use, so to speak.
This is where I'd make a really quick plug for registering your mark.
Yes.
Because the way the trademark office is going to evaluate that registration is they're going to just look at other registrations. Mm-hmm. And so if you turn out to be, I don't know, the first person to register, even if you have that prior user that's out there, you will probably end up getting the mark, which is just a great position to be in. Yeah. And if you don't register first, but you're using it in commerce and somebody else registers the mark, they'll get the registration, and then you're stuck in this position where you have to seek what they call a cancellation, which is like a little bitty administrative trial.
Yeah, or a coexistence or
a coexistence agreement. But so I think this is where, I know we didn't get to this, but one of the reasons why, even though you get trademark protection from the beginning of use, there is a reason to register.
Yeah.
And that is to just get it on paper that you're the first one. Even if it turns out you're not, you're going to be in a better position to
Yeah.
play in that space.
Great question.
Okay, so I know you didn't really talk about like public domain stuff or anything like that, but I was wondering just kind of as someone who's kind of interested in the whole concept of like intellectual property and copyright, whether there were specific challenges to developing and releasing works that are based on things that are not currently public domain but will be in the future, like you know, like if someone was going to make one of those terrible horror movies or whatever, but like, you know, say there was something that comes out that turns public domain in 2027, like when would they be able to start working on that?
Yeah, frankly, as soon as it expires and goes into the public domain, it's fair game. Not fair use, but fair game. And so you can prepare for that. Don't publish it, don't put it into commerce or use yet, but you can always prepare for that. I think that's on the table.
Well, the Winnie the Pooh work is the one you're alluding
Yeah.
to. Is there a Popeye one? Oh, well, good. I was waiting for the Popeye one. Oh, 3, good. More than one. I needed 3.
Steamboat Willie. Yep. So, yeah, no, that's a great question. Yeah, basically you can prepare for it. Just don't publish it until it hits public domain. Because up until that point, it's like there's a big old X on it. Let's go ahead. We got 5 minutes left.
All right, so do you have any advice as to how and where exactly to draw the line for artists contributing to a project to retain some usage over the work that they create? So one example that comes to my mind is the recent C418 and his contributions.
Right.
And then what happened after that. Of course, then you can also think about the person who wrote the end credits for the same game. And so there's all these thoughts about, well, if you're just up and you're still starting up, you know, everyone's just kind of doing it for fun, like you said,
Right.
just a bunch of friends. And you often are all still trying to make a name for yourself, so maybe they still want to be able to use that in other instances.
So what we see, and obviously our firm can't comment directly on C418 for reasons, but that is all to say that in general, you have a way to license back. If you have a contractor that you're working with and you need to own their work, but at the same time you want them to still be able to use it, exploit it, create derivatives, you can license it back to them for their own use. Now you can put approval restrictions on that. You can put limitations on it, like they can't do it commercially or they can only do certain things like interpolations. But in general, you can always build that into a contract. A contract can be whatever we make it. Contract is allowing us to take the law and then break it, but have everybody agree that we're going to break it. So it allows it. It's cool.
And I think this is the one where everyone's friendly at the beginning, and sometimes they think it's going to be a downer if the attorney enters the room. I think attorneys here are facilitators, right? So we're all in good spirits. Hey, let's think about it. What do you want? And like I've had some clients that are comic book writers. They want their artists to thrive, right? So they're more than happy to have license back, all this kind of stuff. We're a team. It's much easier to do that on the front end.
Yeah.
Once things, you know, the money gets involved and all that stuff, it's harder.
Yep. Thank you.
Let's say hypothetically I have a brick and mortar store. Am I allowed to play like retro 90s ads or movies or music?
So hypothetically, unless you have a license to do it or there's a statutory provision that allows you to do it, music's its own thing, by the way. There are commercial licenses for music. I would talk to that guy in the back with his hand up about music. Talk to him about music. But in general, you can get a license for it. If you have purchased it and you're just playing it like locally, generally it's like a practical thing. You're probably fine. But in general, you probably should be careful with how far you broadcast it, what boundaries you have on the space.
You could leverage like the other thing is I was doing that stuff. I would broadcast it from YouTube.
Yeah.
I mean, sometimes there's the sheltering that you can do where you're like, well, I'm just playing what's on YouTube, and it won't get you completely out of jail free, but it's a much nicer position than I've got my own custom CD. Right, exactly.
All right, we're gonna do rapid fire.
Is the composition of game mechanics a form of creative expression?
So game mechanics are inherently not copyrightable unless they are. Yeah, right? And that just throw you for a loop there. Game mechanics are inherently not copyrightable unless you are Wizards of the Coast and have the ability to pay a lot of money to enforce them. I had a big old fight with Wizards a couple of years ago. You might have heard of it, called the OGL. Yeah, you could, in general, game mechanics, not copyrightable. That's the takeaway.
Yep.
You could
Maybe.
Yeah.
But they didn't. All right.
Sorry, I'll my probably pretty quick. Trademarks between like different industries or something. Like, I don't want to get too specific, but like say a banking versus a technology company both have a similar logo or something.
That's A-okay.
Okay.
Yeah.
If you go on Fiverr and you buy a service and there's certain things that are associated with that, does that count as a contract, or is a contract something totally separate?
Fiverr has a built-in terms of service and contract between the purchaser and the creator that is good, but I would generally actually add another contract on top of it, and Fiverr expressly allows you to do that.
So we talked a lot about like physical products, like art and like things that you can hand over as a product. What about more like entertainers, your YouTubers, your Twitch streamers, stuff like that? Practicality of copyright, branding.
You're not going to find a content creator that copyrights every single stream. It's just not possible. You should always trademark. For example, we represent over 1,000 content creators on Twitch and YouTube at the firm, including retired ones like that guy in the back. But what I would do is typically we register their trademarks, and then we use the DMCA to protect their works so that they are protected on that front.
Would you have them keep copies of their old streams? I mean, because the one thing about it is there's an evidentiary issue,
right.
And I would keep copies of all your old streams. Don't rely on the service.
Yeah.
We've seen this before. Don't rely on the service to keep copies of them.
Keep your VODs and post them to YouTube. It's good evidence. So.
What are your options to protect a trade secret that's been made public? Like you said, you can't
None.
put the toothpaste down. Oh, okay.
Unless it's something that you can copyright or trademark or patent. So if there's another way to protect that, then you're good. But if a trade secret's made public, nothing you can do, right, bud?
Yeah, I mean, unless somebody else did it, and then I can sue them for misappropriation of the trade secret.
Yeah, but
right,
then, even then.
Right, I mean, this is the Apple foldable phone situation that's going on now. But yeah, if you did it yourself or you just weren't good about keeping it secret, oh well.
Now, in theory, you could make a filing that would limit who can see it, and you can try and put the cat back in the bag. But once it's out, it's really
You're just going to
hard.
be trying to get whatever remedies you can get from the person who did it.
Yeah, at that point, you're doing band-aids rather than stemming the flow. So.
So I want to talk about characters.
Uh-oh.
So if you create a group of characters, for example, Disney has like Mickey, Donald Duck. Do you put all of them in one case, or you have to copyright each single characters and different poses?
Great question. The answer is yes. You can put them as a compilation of characters. You can put them as individual characters, individual poses, especially if some are particularly iconic or something like that. And Disney loves to do that. But yes, you can copyright characters every which way and sideways. So it's very fun. You see a lot of actual players these days doing that now, like Critical Roles of the world, etc. And they do a great job of doing that because their characters are so iconic. They want to make sure that they're able to protect them from secondary market usage. So great question. Fantastic. And we are lawyers. Thank you all so much for coming.